So inappropriate or unwarranted discipline for concerted activity not just can result in liability under the NLRA, but it can also lead to workplace morale complications. If people feel like they don't have an outlet and that Big Brother is watching them and Big Brother is monitoring their Facebook postings, it's not going to help morale. It's going to increase water cooler talk. It's going to make employees not as happy, and all these things lead to lower productivity. In the red box there at the bottom, protected concerted activity refers to communications between two or more employees concerning workplace conditions. Example is employees discussing wages and raises amongst themselves. Probably the most common example is talking about wages. We're not paid enough. We didn't get good raises this year. I can't believe that person makes more than me. Those sorts of things. Now, this tends to fly in the face of how we view our job in HR, because we view a lot of the information that we run across as confidential. And frankly, it should be confidential. People's personnel files, how much they make, what their bonus is, what their commission structure is, that's all pretty sensitive information. The National Labor Relations Act says that is protected information to talk about. So that doesn't mean that someone can break into your office after hours and look through people's personnel files. So the method of obtaining it is still protected. It's not a free-for-all to get it. But once someone runs across how much other people make, the NLRA says they are free to talk about it. And yes, Chuck?
Question. Do you see very many companies blocking access to the social media sites so they can't even get on it?
I do these days, because I think they realize that it can lead to a loss of productivity, and it is something that you really do get sucked into. And if you let employees have unfettered access to their personal Facebook site, the risk is that at least one of them is going to spend hours and hours a day Facebooking or updating their Flickr albums. So yeah, I do see that this is something that organizations are getting on top of. To give you a little more insight into what concerted activity is and is not, I wanted to walk through 4 recent cases with you, 4 actual cases. The first is an employee of the Philadelphia Eagles, Dan Leone. He was not a player, he was a gate worker, okay? So he was a gate worker, and back in 2009, the Eagles traded a player known as Brian Dawkins. He was a safety, traded him to the Denver Broncos. Well, this was Dan's favorite player, and he was none too happy about this. So he took out his frustrations on, well, they didn't trade him, I guess they lost him to free agency. So Dan gets on his Facebook page and posts what I've quoted there. Dan is effing devastated about Dawkins signing with Denver. Damn, Eagles are retarded. Not a professional, not a very nice thing to say. Could it have been worse? Sure, it could have been worse. I guess anything could be worse. The Eagles find out about this and they fired him for it. Dan did not even proceed to file a charge of an unfair labor practice charge with the National Labor Relations Board, but this case got a lot of media attention. It got it in sports circles, and it also got it in employment law circles. This is clearly not an example of concerted activity for a couple reasons. First of all, because of the content. He's not talking about workplace conditions. This is an instance of an employee talking about the company's overall business decisions. Okay, so for instance, if you work for an organization who decides they're going to expand into the Los Angeles market, or they're going to close their Los Angeles office, and you disagree with that business decision because you think you know more about the market than they do, and you criticize them and you go over the top, that's something you can be legitimately disciplined for. if you complain about customers, that's something you can be disciplined for. It only protects workplace conditions, conditions of employment. He's not complaining about conditions of employment here. I suppose if he had said, boy, people are going to make my job harder as a ticket taker on Sunday afternoons because this player isn't here and people are going to be giving me more slack. Okay, now it's getting into that context. But that's not what happened. It is what it is. The other thing is, was this concerted activity? No, this was not concerted. Concerted means you're acting in concert, either explicitly or implicitly. So it needs to be involving 2 or more employees, or at least the content, at least implicitly being on behalf of other employees. Here it's not. He's just expressing his own personal opinion about something. So he got fired for this, and he didn't have any recourse. As it turns out, I guess a silver lining to the end of the story, Brian Dawkins, the actual player, found out about this and gave him free, I think gave him free tickets to some of the games. So, this got some publicity, and this is a good example of something that's not protected concerted activity. However, the next one is in part. Robert Becker and Knaus BMW. This was a BMW and other luxury car dealership up in Chicago. And what Mr. Knaus decided to do as a customer appreciation event to get people into the dealership is to hold a customer appreciation event on Saturday afternoon, which is not uncommon. And what he did was, the kind of food he served was kind of stale buns and boiled hot dogs and chips and cookies and bottled water from Sam's Club. And Mr. Knaus thought this was a good idea. Well, Becker was there with his fellow salesman, and he thought this was ridiculous because he thought the kind of people who are going to come in here and buy BMWs and Mercedes and Land Rovers are not going to be impressed by Sam's Club hot dogs and potato chips, okay? And they thought this was ridiculous. And they were all there, and they're young guys. They had their smartphones. So they started taking pictures, making silly faces, and, posting on their Facebook page with the pictures and, making fun of the event and the food that was served there. So that's one thing he did. Also during the event, across the street is a Knaus Land Rover dealership. And a potential customer with his 13-year-old son go and check out the Land Rovers, and the 13-year-old son says, "Dad, can I sit behind the wheel of the Land Rover?" So Dad, wanting to be a good dad, says, "Sure, go ahead and get in." Well, the 13-year-old boy was a little too enthusiastic, didn't want to just sit there. He puts it in gear and turns it on. It lurches forward, it rolls down an embankment, and goes into a lake. Now, everyone's okay, so we can chuckle about this. So the Land Rover crashes in the lake. Well, Becker and his fellow salesmen think that's real funny. They run over there and start taking pictures. And he posts on his Facebook page a picture of a Land Rover that says something like, "This is your Land Rover," and then another picture with the Land Rover in the lake that says, "This is your Land Rover on drugs." And they thought that was real funny. So a week later, the dealership sees this Facebook page, calls in Becker, and fires him. Well, Becker files a unfair labor practice charge with the National Labor Relations Board. And this situation actually raises some very interesting legal issues. And the board made a distinction between those two things. The Land Rover incident, they said, that's not protected. That's not concerted activity, because what are you doing? You're making fun of a customer, or you're making fun of some incident that doesn't involve your workplace conditions. So that is not protected. The making fun of the hot dogs in the event, that is protected. Okay. Well, this is a good example of what we're dealing with. Here's a situation where Becker and his friends are doing something pretty public. I don't know how many friends Becker had on his Facebook page, but he's posting pictures and he's making fun of his employer and his employer's business decisions. And his point was he got it into protected concerted activity because he closed the loop and said, this is going to make it much harder for us to make sales Because if we're attracting these people who, are impressed with hot dogs and potato chips, says Becker, that's not the kind of market who's going to be able or willing to buy the kind of products that we're offering. So Mr. Nous is making it a lot harder for us to do our job and make our commissions and put food on our table. So the board said that's protected concerted activity. The Land Rover incident isn't. So the question is, what was he fired for? Which one of the two or both? Well, the board said he was fired because of the Land Rover incident. The commission, the arbitrator with the board believed the employer, who said the real reason I let him go was because of the Land Rover incident only. So the arbitrator believed that and said, well, if that's the case, you're okay letting him go because the Land Rover incident, making fun of a customer or the situation, that's not protected. However, if you had let him go because of the whole hot dog customer appreciation event, that's going to be protected concerted activity. So here's what we're dealing with. He's making fun of his employer and his employer's business decisions and saying, how am I supposed to do my job? And that's actually protected under federal law. Well, I don't think that is consistent with common sense. So it's something you need to be very careful about. Let's look at a third case. The third case is JT's Port Saloon and Eatery. This is a bar in Lombard, Illinois, a suburb of Chicago. And we don't know the bartender's name. And he wasn't the only bartender there. But he was upset because he'd worked at this bar for 5 years, and he hadn't gotten a raise in 5 years. And a policy that he was upset about was that he was required to help the waiters and waitresses serve their food, but he was not entitled to share in their tips. So he had to help them out, but he didn't get any tips out of that, no tip sharing. So he goes to work one night and he comes home and logs onto Facebook, and his stepsister asks him, how was work tonight? Well, that set him off, and he just unloads. And he says, well, let me tell you how work was. I haven't gotten a raise in 5 years. I'm really unhappy at work. I have to help out the waitresses and don't get paid for it. And as long as I'm talking about it, the customers are a bunch of rednecks. And I hope they choke on glass when they drive home drunk, stepsister. So, yeah, I guess the stepsister's question about how was work tonight just set him off. So he let it all hang out to her.